I want to stay with my best friend who's a neighbor, and the parents are willing to take them on for a year and a half, and everything in the home looks good. It looks fine. A judge is much more likely to give credence to what that child says at 16 and a half versus 3. Well, now let's get on to the tough question, as if the other 3 weren't tough enough. Who's going to raise minor children? Now, this is one thing where there are several factors where things are not absolute. The other parent of a child has some constitutional right to parenting, but that can be overcome. So there's this presumption within the law that a child is better off with a biological parent, and the biological parent has some constitutional right to be the parent for their own children up until they reach age 18 or whatever the age of majority is in a state. All right, so what does that mean? Well, it means if you're going to be picking guardians and you want to pick your current spouse or partner to take over guardianship, it's not likely, but it can be overcome. There's got to be some reason why the other parent is not fit or suitable. Now, what do you do if that is the case? Trying to terminate parental rights, it's got to really reach that level that they're so neglectful or abusive or just absent that they shouldn't be allowed to continue to be a parent, and you can go to court and have that parentage removed. But most people don't do that. And I've had a lot of clients say, oh, they were absolutely horrible as a spouse. Horrible. But I can't fault them. They were a good mother or a good father. They were a good parent. All right. So it's not uncommon when nominating guardians to have that other parent be in there. So as you'll see, we get a little further. It's having separate lists for different children is not out of the question. So that other parent does have some rights. Now, if the parental rights weren't taken away from the other parent, but they should have, this is something I've done a couple of times, documenting all of this stuff on why. So, all right, that becomes part of a potential down the road issue. Thankfully, in all of the cases, the kids reached age 18 and nothing was needed in terms of that guardianship, but that proof was there.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
May want to have different choices for different children, and for the same principle, individuals and not couples. Most people, I want my brother and sister-in-law to be the guardian. No, you want your brother. Your sister-in-law is there, but it's your brother. Well, why not name both? Because there's a 50% divorce rate, and you don't want that. You don't want both of them being divorced, fighting over this in court. It's your brother that you want. So what are some of the other issues when we're talking about guardianship that are a little bit different? And this is one that's more across the board. It's that your choices are not absolute. A judge always has to make that determination. That's just the way it is, because people don't address their estate documents like this nearly often enough in the general public. So, I named my brother as guardian in a document 11 years ago when my kid was born. And in those 11 years, the brother's been in and out of rehab, in and out of jail, selling drugs, whatnot. The court's not going to just go, oh, yeah, sure, go ahead, here, take the kid. No! They have to have a hearing to determine what's going to be in the best interests of the child. Now, usually they have to find some reasons to not go with your selection, but they could. And additional factor, the older the child is, the more of a say they have. Picture this, and this is a pretty standard thing, example that I give to my clients. You got a 3-year-old, and Uncle John is supposed to be the person that you've nominated to be the parent, the guardian. And the 3-year-old goes, "No, I want to stay with my best friend's mom. They're neighbors, and I want to stay with them." Well, the judge isn't going to give all that much credence to what a 3-year-old says. On the other hand, it's a 16-and-a-half-year-old. They're getting ready to go into their senior year of high school. They're going to be starting on some sports team. Because of that, they've got some potential scholarships that could come into play. And it's, look, I want to stay with my best friend who's a neighbor, and the parents are willing to take them on for a year and a half, and everything in the home looks good. It looks fine. A judge is much more likely to give credence to what that child says at 16 and a half versus 3. So those are some of the factors that go into that.